Good afternoon, folks, and welcome to this week's episode of the Legal Beagle podcast. For those that are unaware, for those non-attorneys, I am part of a listserv of attorneys nationwide, on a listserv called Trial by Human. It was started by Nick Rowley, and it is a collective group of what I consider the most brilliant attorneys in the country. And it's really a helpful tool for a variety of reasons. You can go to this resource for help. People share thoughts on different concepts and ideas and theories of law. And there's just a good, healthy dialogue. My guest today is Grant Gehrmann. And Grant, I'm gonna call what he did recently, earlier this month, as the post. Grant posted on Trial by Human about mediations. And we're going to talk a little bit about mediations, but I want to talk to Grant about this post, because this post raised a lot of eyebrows, and it certainly created some controversy amongst our own group about the idea of mediations in the work that we do and whether or not we should be going to mediation. So, Grant, I'll ask you this question. Why are mediations bad?
Well, they're not bad necessarily. My point was, and the title of my post was, mediations can hurt your case, which is a very non-traditional way of thinking, because historically, we as plaintiffs' attorneys, the typical way would be, well, we're going to mediate because even though we're spending some money, we're going to at least learn something. And most importantly, we want to try to get their top number on the table, and at least that was kind of the orthodoxy for many, many years. And over the last couple of years, I just started thinking about it more and more, and like listening to my clients before and after mediations that both are successful and aren't. And it occurred to me that maybe we should discuss a little bit about whether the traditional orthodoxy regarding mediations should be challenged a little bit. So, my specific post was that there are situations where I believe that taking a client to mediation actually hurts your case, particularly in cases that are unlikely to settle and that are likely going to trial. So I did not anticipate so much blowback. But I wanted to at least broach the topic and put it out there. I still think, despite the blowback, that my conclusion that it may be the case that certain personal injury cases are hurt by mediation, I still think that is sound. I do think, despite the blowback, I don't know why people were so uncomfortable with my post, because really, but it's fine. I mean, that's what it's all about. We as trial attorneys, I love the Trial by Human listserv. I've attended a couple Trial by Human events, and really, what started me thinking about this is Nick Rowley talking about we can just say no to mediation. And he encourages, mediations aren't necessarily, he kind of got me thinking on that, of just saying no, or that at mediation, you say, look, our demand is a jury trial. So even if, which I think is sound advice in certain cases, I think Nick's right about that. But we still we're not really comfortable with change or just saying no to mediation. So I started thinking deeper about it, realizing, you know what? Not only sometimes should we not do mediations, it can potentially hurt the case. And I can explain more about why I think that. I use a specific example in the post, but that's really what got me thinking, is Nick talking about maybe we should just say no to mediation, and then realizing that most people still do mediation because it's traditional orthodoxy, but that maybe we should look a little deeper at ourselves and are we really helping the client? Because in my mind, ultimately, that's what you're trying to do is help the client. But I believe that mediation can hurt certain cases.
Well, you're talking about disruption theory, Grant, and anytime there's disruption, people get uncomfortable. And I saw that reading all of the comments and the posts and the responses to your original post. Before we dive into your analogy and the story you used in your post, I think it's a very good analogy to share with the audience. Can you explain what a mediation is? I know that sounds very rudimentary to you, but there are a lot of
Sure.
non-attorneys that watch this. And so what is a mediation? How does that fit into a personal injury case? And why would a party even go to mediation or maybe not go to mediation? But what is mediation in the first place?
That's a great question. Um, so, first of all, a mediation is a process where two sides, in the context of a lawsuit, where two different sides, they both hire um, a neutral person to act as what's called a mediator. There's a lot of confusion between arbitration and mediation. Arbitration is similar in that you have a judge or an attorney normally who will hear actual evidence and render a decision on a case based upon evidence. That process is called arbitration. Arbitration is different than mediation in many ways. Um, Mediation is a little bit more of a relaxed atmosphere where the mediation remains confidential and the mediator, unlike an arbitrator, does not make a final decision that can affect uh, the parties and bind them to what's called an arbitration award. So a lot of times you have situations where people have contracts and there's what's called an arbitration clause. And that means that if there's a dispute among the parties, that they would agree to arbitrate, in other words, present their evidence and counter evidence to an arbitrator. And the arbitrator then would make a decision that would resolve the dispute between the parties. That's arbitration. You asked me about mediation. That's what we're talking about. Now, mediation is a little bit different. It's a good question to ask what it is because most people don't really understand it. Typically, in a mediation, there's no specific or formal presentation of evidence. There is a mediator that's hired. Often, mediators do both mediations and arbitrations, but focusing on mediations. There's a mediator that is hired by both sides. That mediator's job is to try to bring the parties together, settle the case between the parties, and wrap up the litigation or potential litigation. The process that a mediator engages in is typically parties will be in different rooms. This may be Zoom rooms, or the traditional way of doing it, they might be in the same building but in different offices. The mediator will shuttle back and forth between the two offices, discuss strengths and weaknesses of the case with both sides. Normally, it's a process that starts out with the mediator listening a lot to both sides, giving input, and then sharing information, certain information, with the other side about the strengths and weaknesses as the mediator sees it. Interestingly, with mediation, the parties are not in the same room. So nobody gets cross-examined or anything like that. The mediator, typically the mediator's role in the first stages of mediation is to listen, to gather evidence, to understand, and then throughout the mediation process, try to bridge gaps between the parties to get them to a number that works for both. So the first part is establishing communication. And the second part is of the mediation is typically trading numbers back and forth, where the plaintiff will come in, ask for a high number, the defense will come in with a real low number, and they'll actually trade back and forth offers to settle. So the plaintiff would start high, the defense may go low. The mediator is the person that goes back and forth between the rooms and shuttles back and forth the numbers. Good mediators not only shuffle numbers, they also will transfer messages and kind of, I mean, really, the brutal honesty of it is that mediators come in against plaintiffs and bang on their case, right? That's the reality. And then the other side, the mediators are banging on the defense on why your case is good and why they need to pay more money. They come in with the on the plaintiff side and say why your case is bad, you know, even to the point where some mediators will try to scare participants a little bit. You don't want to roll the dice, you don't want to do things. So that's all part of their job. And typically before mediation, I let the client know, listen, this is normal. It's not an attack on you. We're trying to keep it a courteous and pleasant experience. We're going to have disagreements, of course, but that's the mediation process. So as it goes into numbers, then the mediator will trade numbers back and forth. I kind of think of mediation like, if you could picture like a medieval map, right? Like you see maybe on Game of Thrones or Lord of the Rings or something. And there's two riders riding their horses across the landscape, right? And they're riding towards each other, but they can't see each other. The mediator kind of directs the two horses riding towards each other. And at some point, usually later in the mediation, both parties are going to be kind of stuck, typically. And they're going to sit on their horse and look out and see if they can see the other horse. And a lot of times, if they can now see the other side and they're close enough to actually see each other, oftentimes both parties will gallop the horses at each other and reach a mediation. That's kind of the metaphor that I use. And a lot of times, though, when mediations fail, you work, you get to a point where you're kind of, for plaintiffs, below your comfort zone, for defendants above your comfort zone in terms of damages. They'll stop, look, and if they can't really see the other party, I'm using that as a metaphor, then there's the mediation typically fails.
That's a fantastic metaphor because it gives you a visual. As you were sharing it, I was like, wow, that's a really good way of looking at
Thank you.
whether the parties can bridge that gap and that distance between each other. And thank you for differentiating an arbitration from a mediation, because I do think there's a lot of confusion, sometimes even in our own group, about how those two things work in a case. Why can a mediation be bad? And now I'm really specifically asking about the analogy or the story that you told in your post, because I thought it was great, thought it made sense. I've been in that situation myself. What can you share from that story, and maybe just share the story for our audience, and then talk about how this can backfire on a case?
Sure. Yeah. So I gave just a hypothetical example of a typical case that I'm sure a lot of plaintiffs' attorneys are familiar with. I don't remember the exact post, but it was basically this. Let's say you have a 30-year-old female client who was in a moderate impact rear end case. She goes to the emergency room. She's checked out. She's diagnosed with sprain strain of the low back. She tries some therapy. She does physical therapy. Then she tries some chiropractic. The imaging really is not indicative, or at least doesn't show what's going on. The pain continues. 3 to 6 months goes by. She gets seen, say, by a pain management expert or other back specialists. And the diagnosis becomes that she's actually got an injury to the disc area that, although it got better with therapy, is now chronic. Her medical providers say it's likely permanent. She has a typical daily pain level of 2 to 3, with that increases with activity. So her medical bills in this example, I said are about 22,000. The plaintiff's attorney puts together a demand package. The insurance company writes back and says, typically they'll probably contest some of it, whatever. But the bottom line is that they offer 25,000, maybe. So most of the medical bills plus just a few $1,000s. So the plaintiff's attorney files suit. You're in litigation. You prep your client for deposition. She does pretty well. The doctors are not professional experts or her treating doctors, but they come across pretty well and credible. And they are going to testify that although unfortunate and although it's not devastating to her, it's permanent and we can't fix it. So you get ready for trial, and then a few months before trial, the defense asks if you would be willing to mediate the case. Now, in this situation, they've offered 25,000. You, because of your typical, the plaintiff's attorney is going to realize, look, this is unlikely to settle because the insurance company is not going to put what you likely believe is fair damages for a permanent back injury on a 30-year-old client. So, but you agree to the traditional way. The plaintiff's attorney agrees to go to mediation. So you go to mediation. You, after a long, long day with your client, you spend 4 or 5 hours in mediation. You finally get the defense insurance firm up to a number more than they were wanting to pay. And let's say it was actually more than they want to pay. But the mediator got them to $86,000. All right. So as I said in the example, 86,000, this is where a lot of attorneys would take that and advise the client to take it. I also said that, if you're a trial by human attorney and you follow the teachings of Rowley and feel good about your skill set, I think that a lot of TBH attorneys would say that's insufficient. So since I was addressing the trial by human group, I said, all right, so you take this, so you tell your client to decline it, right? So here's where it gets interesting to me. And that is, it's important. I think all attorneys do this to a certain extent, but it's really important in this situation to put yourself in the client's shoes, right? So in my example, let's just assume that she's a single mom, nice young lady, but in some financial distress, and her netting out about $50,000 on that case would be a huge difference in her life. But you advise her to decline the offer. So fast forward, you go to trial. Your costs were about 5,000, but now they're up to about 25,000. Because you brought in all the experts, you've done additional depositions, you're putting on the case. So your trial is going. You're a few days into your trial. The defense hires defense medical examiners. In my example, I said, who, because of scheduling issues, that they claim, get called right in the middle of your case in chief, which the judge allows because there was a conflict and these defense experts, could only appear on Tuesday, or Tuesday in the afternoon. So you hear from the defense experts. Well, you hear from them, you do a good job on cross-examination, but your client hears them too. And you hear the experts say it's it's somatoform disorder. There's no clinical basis for any of these conclusions. That she did have chiropractic 7 years before, and it's probably something from that. Everything under the sun that is unrelated, or she's a liar, fake, and fraud. Right? You brush it off because you've been in trial, but your client is hearing all this, right? And she asks you, as the trial progresses, how are things going? You say, pretty good. I feel pretty good about it. You also recall that she asked you and helped you pick the jury, and that you felt pretty good about the jury, but you really have a few people that you're not sure about. You exercised all your peremptories, and you do think that there is some danger, which you share with your client, of, we have a few people on here that might be pretty hostile to injury claims, and so that's kind of the context, and the client thinks about this, and midway through trial starts asking you about, well, first she starts thinking, maybe I should have taken that money because this is extremely stressful. She starts second guessing her decision, right? She also is getting really nervous about testifying. She's seen what the defense has done to her own doctors, who she thinks are great, and they are great. They're smart, but the way they were attacked. They see that you have attacked the defense medical examiners. She hasn't been on the stand yet, but it's coming. She's getting really nervous. And here's the key: more than getting nervous, right? She's putting a lot of pressure on herself. She sees the amount of work that everybody's putting in on this case on her behalf. And the pressure is building for a person who's never, ever been in court. So she asks you again, well, is that offer still open? Right? Because now she's starting to get nervous, and she's not only putting pressure on herself, but she also kind of is starting to wonder, I like my attorney, but is he right on this? Right? So the attorney tells her, look, everything is going to be fine. I plan on asking for, $2 million or something. And in an effort to make her feel better, that, we're going to be asking for a lot more money than that. But that backfires. And the client now thinks, oh my gosh, right? Because she's the type of person who, if she were on a jury before she was ever hit or hadn't knew anything about it, she'd never give millions of dollars for a crushed bumper with some back pain. I mean, that's just totally foreign to her. So now she's heard you say that, and she starts thinking, oh my gosh, I mean, I didn't know. Yet more pressure, right? Yet more questioning about you. So I ended the hypothetical with your client asked, well, will I still be able to net out the same amount of money? And you're like, no, because now your fees have gone up and your costs have gone up 500%. So she knows all this. She's getting ready to go on the stand. How do you think she will do? And that's how I left it. That's it. And I just said, look, this is an example of where you mediated a case, okay? You got their top offer on the table, but the net result of this is extreme pressure that your client has put on herself, right? So if you just go to trial with that low offer, right, then that's a no-brainer. You're going to take it. Your client wants to take it. She's back with you. So again, this is not every case, but this is a typical case where I think mediation can hurt, because I think a lot of times attorneys are not really putting themselves in the client's shoes for how a mediation top offer that is rejected may affect them during the trial process and hurt your own case.
I think that you touched on two things that may have sparked such a backlash in this post, and you mentioned the one here, which is putting yourself in the client's shoes, remembering that you represent someone who has no legal training, who has no understanding of this process, who has a lot of discomfort in this entire situation. The idea of being deposed, the idea of going to trial, the idea of testifying, the idea of asking a jury for a lot of money, and really trying to understand what that must feel like, and not forgetting that, although you, the plaintiff attorney, may have 100 cases, this client has one, and
Right.
they're very unfamiliar with this landscape and how to navigate it, and they're leaning on you, the attorney, to walk them through it and give them good advice, sound advice, not for your own benefit, but for their benefit. And I think
Right.
that, and again, I'm not trying to ostracize myself from, the trial by human listserv, but I think that some of the comments that you faced may be those attorneys that have forgotten that they represent people, or that it's their job and their duty to put themselves in the client's shoes. The second thing is, I wonder, and this is just my own thought, and I want to get your thoughts on it, Grant. Is there maybe this discomfort with trying cases, and people, the attorneys that were pushing back, maybe there's this concern, I can't do better than the hypothetical amount you gave at mediation? And am I committing some sort of legal malpractice, or am I doing a disservice to my client by taking this to trial? What are your thoughts on that second prong of this? The people that may have just a discomfort with going to trial, and can they better the result for the client?
That's an excellent point. And I think very reasonable. And I addressed that a little bit later in my post too. And I said, look, first of all, if you feel that way, that's okay. Okay. I mean, everybody's been there. And it's first recognize that it's okay, as an attorney to be afraid of that. But my point is, develop the skill sets to be able to be comfortable with taking the case to trial. Attend CLEs, do training, train with other attorneys in your area, read the books, keep yourself current, and actually practice things. And really, so in my mind, first of all, and the other thing is, like early in my career, I would often associate with more experienced attorneys, associate with other attorneys that second chair it. Don't worry about, oh, well, if I bring somebody else on, is that going to cut down my fees? Who cares about that, right? In the big picture of your career, work with attorneys that you respect and that are good. Second chair, maybe just do part of it. And really develop your own skill set, so you are confident with your ability to present a story to a jury, to present the truth, to overcome difficult defense witnesses. So I guess my answer is, first, it's okay if you feel that way. It's totally okay. It's totally normal. All right. But continue to work by learning, okay, and find things that will help you be your best you, right? Not nobody's going to be, like the top people. I mean, I look at the top people in this business and I'm like, wow. I mean, I think it can be intimidating sometimes. Like, wow. I mean, I don't know if I could do what these men and women are doing. I mean, they're incredible, right? Everybody has a little of that, and that's okay. I think the key is, um, make peace with your own skill set and be the best version of yourself for your client. You don't have to be somebody else, but if you come to court and you have the basics and you practice and you engage in frankly, let me just take a quick sidetrack if that's okay.
Sure.
I often felt when especially early in my career, I don't want to appear vulnerable in court, right? That's we think it's always a big fight. But here's the thing. Vulnerability is really putting yourself out there and not really knowing how it's going to turn out. It takes a lot to be vulnerable in court. But here's where I think a lot of people are mistaken about vulnerability. If you are the real you in court, you, even if you're nervous or you mess things up and you just say, I'm sorry, I screwed that up. Or if, a cross-examination is not going well, you just admit it. You know what? Maybe I kind of rephrase that. I lost myself, right? That's being a human being, and it's okay. And jurors are not going to punish you simply because you put yourself out there and made yourself vulnerable. As long as you have a basic skill set and are honest in the evidence that you present and your witnesses are prepared, you don't have to be perfect. Just be you, be the best version of yourself. And so to me, um, that's that's the way to address that. And if it's one thing to hear lawyers say, "Oh, do this, do that, do this," I get it. It is really hard, but learn the skill set, practice, continue to learn throughout your career, um, and feel good about it, and feel good about yourself. This may sound kind of corny, but it's like when I'm in court, I I really I try to live my life this way too. It's like I think to myself, I want to radiate happiness generally. There's so much negativity, right? And so if you can radiate happiness, even if you fall down, okay, and you radiate truth that the jury sees you're trying not to pull some attorney tricks, that you're just trying to present your case in an honest way, and in a way that is positive, okay, that I think that can be very effective. So I also think if we can radiate happiness, and not just in court, but in when you go to pick up your laundry at the grocery store with the checkout people, be nice. Just be nice to people. And that positivity is contagious. And unfortunately, we're really in short supply of that a lot in our society. So I try to radiate positivity to everybody in the courtroom. Well, again, I notice some of you are just, fight it out. This is going to seem weird, but I really think that this radiating positivity and having a respect for everybody in the courtroom, including defense medical examiners, including defense counsel, right? They may get down in the mud, right, of negativity and attack. You don't have to go there. You stay on course, your course of positivity and truth. And more likely than not, good things will happen.
I love radiate positivity. And I the sidebar that you you had, the non sequitur of this idea of being you, is so important. I've had the honor of having Nick Rowley on this podcast, and Keith Mitnick, and others, and they will all tell you that, Grant. And I'm glad to hear it from you. Be yourself. Don't be them. You can learn from their teachings. You can borrow from some of their best practices. But at the end of the day, you have to be the best version of yourself. And I love to hear you say that, because I tell that to the attorneys at my own firm. I tell that to other attorneys that are here local, that you can't get caught up in trying to be someone else, but you can learn from the way they do things. And I think that's what you were saying in this post, is learn from what
Right.
Nick Rowley is talking about in terms of mediations. And it maybe went sideways unnecessarily. One thing I noticed in this post, a lot of comments about jurisdictions that require mediation. And I want to address that, and then I'll let you jump in if you want, Grant. But here's what we do. Arizona is one of the jurisdictions where we practice. We also practice in Colorado and in California. And they're not required in California. And we now require the defense to make a hard money offer before we'll even contemplate a defense offered mediation. So they got to offer a decent amount. If it's not a decent amount, we just did this on a case, then we don't even go to mediation. In fact, the defense attorney in one of our recent cases in California told us he had never in his 25 years of practice been forced to make an offer before mediation. I thought that was great. That means we're changing the way that people are looking at
Yeah.
mediations. Now, backing into Arizona, where it's mandatory. It is mandatory, but it is not mandatory that you go to private mediation, which costs your client a lot of money and is a little bit more involved than I think what you would get in a settlement conference that's ordered by the court. And the reason I bring this up is because before in Arizona, we had to put together a scheduling order for the case. And it was very customary for us to check the box that said private mediation. And then later on down the road, we were trying to pick a mediator and decide how we were going to do that between the parties. And then you bear the cost of that. You split the cost of that, even if the mediation is unsuccessful. And oftentimes it is. We've gone away from that practice and we now go to the court ordered settlement conference that doesn't cost our client any money. And if the defense wants a private mediation, then they've got to put a hard money offer on the table that is legitimate enough for us to go sit down in that room and have that conversation, because there's no reason to spend our clients' money or put our clients in the position that you used in this hypothetical if it's going to go nowhere. And I'm not trying to disparage the judge pro tems that are assigned in these settlement conferences, because some are well equipped to get cases settled, but some of them are, as you've said, just shuttling numbers back and forth and really can add no value to the case and really don't have any skin in the game because they're court appointed. And really, if the case settles, great, and if it doesn't, fine. They're doing their civic duty by presenting themselves to the case as a judge pro tem. The reason we've done some of these things are because they're practices that I've learned from Nick Rowley. And I thought they were good practices to adopt. And we talk to our clients about it and we explain their options and we give them the choice and we really help them understand what could happen. And the reason I wanted to talk to you and I wanted to invite you on this podcast, Grant, is because I think what you were saying is so spot on. And I was shocked, maybe as much as you were, maybe more than you were, at the backlash that you faced, because I thought it was a really good example of when mediation will not work, does not work, and will have no benefit other than to make your client really have their stomach turning in knots and become so at odds with you, the attorney, that it doesn't offer productivity. And it certainly doesn't offer positivity, as you're talking about. And so I was surprised to see such a negative response. And I can only think of those two things as the possible reasons: people afraid to try cases, people not wanting to put themselves in the shoes of their client. Maybe the third ancillary reason could be the court mandated mediations in certain jurisdictions. But again, I'll give you that. I just gave you a solution on how to deal with that. I want to wrap this up with this question to you, Grant. Are there times when mediation can be beneficial?
Absolutely. Absolutely.
Give me some of those
Yeah.
examples or times where you would say it would work.
Yeah. So where mediation can be definitely beneficial is in complex cases where I've done pre-litigation mediations that have been very productive because we were able to learn a lot of things about how the defense was seeing the case. If you can anticipate what areas they likely will go, what I think can be productive is pre-litigation and post-litigation. Anticipate where the defense will have some questions. Like, take a hard look at your case put yourself in the defense shoes a little bit, right? And then have solutions and have things that you can share with them. So to answer your question specifically, yes, mediations can be very productive. What I was talking about is there are certain times of cases where the defense is nowhere going to get close to your evaluation of the case, that it can be counterproductive. But in situations where the defense has worked up the case and you have gotten a good kind of a gestalt feel about the case and the other side, frankly. because I don't believe in the adage, never ever trust a defense attorney. No, I mean, they have a job to do too, right? So there can be a lot of cases that mediation is productive, especially where in your situation you set some basic parameters where there are reasonable offers that are being sent back and forth. That's a different situation than the typical case, and where offers are being sent back and forth before mediation, right? Um, then that's different than the typical case, which is you go in blind. 90% of the time you're not going to get anywhere, but you still do it because you're stuck with the orthodoxy uh, oh, I have to mediate everything. So um, so yes, I think mediations and some mediators are absolutely excellent at, at getting a case to resolution. And so I'm not poo-pooing the mediation process. I think mediations can be very helpful. I just think that we need to recognize that in cases where the chances of actually getting to a number that you will recommend to your client are extremely low, where the chances of that are very low, there's no need to spend the client's money and time, and it may actually hurt your case at trial.
I completely agree. I'm glad you posted it. I hope that the backlash does not dissuade you from posting more disruptive thoughts on how we can better our practice. I thought it was fascinating. I really do. I mean that. That's why I invited you on as a guest. Grant, before I let you go, I end every podcast the same. I ask my guests 5 questions quickly. They're not all yes or no answers, but would you indulge me in that?
Sure.
Okay. First question. You're in Vancouver, Washington. Do people ever mistake you for being in Vancouver, British Columbia?
All the time.
What is the hardest
not
thing
not in
about
law not in law circles, but especially when I'm traveling and I say I'm from Vancouver, Washington, they think I'm from Canada all the time. Everybody from Vancouver, I think, gets that.
Sure. Yes. What is the hardest thing about running your own practice? If you had to name one thing.
Um, One thing. It can be lonely.
That's a good
And
thing. I
so
mean, it's not good to be lonely, but that's a
no,
good thing to
it can be
share because I
lonely.
think a lot of people don't recognize that.
Yeah, it can be lonely. And that's why I think I mean, I am so fortunate to have an amazing paralegal who's been with me for 16 years. Um, and so I have somebody who I respect in her analysis and opinions. So it's not as lonely for me, obviously, but true solo practitioners, I think that can be difficult. And what I would say to sole practitioners is um, really reach out, because the idea that, and what I mean is reach out to other attorneys in your community, because um, we're not all in competition, right? And reach out to other solo practitioners, and you might be pleasantly surprised if you just have lunch once every couple weeks with one or two, and share ideas and keep in contact. That really fortunately, I have a great group of attorneys here in Vancouver that I'm friends with and can call and bounce things off of. And I would recommend that people really foster those relationships with other people, because your stress and the struggles that every solo practitioner has, you're not alone in that. And sometimes it helps hearing from other people and hearing how they deal with it. And importantly, you may be helping them too. And when you're helping other people, that comes back to you.
Grant, being that you're from Washington, do you have a favorite apple? Favorite type of apple?
Yeah, I like Honeycrisp, we call it. So I
Oh,
don't.
those are good.
Yeah, those are good. Those are my favorites.
Okay. I looked on a map because I wasn't actually clear on where Vancouver, Washington was. You're right across the water from Portland. Is that true?
Yeah, that's correct. Yeah, we're right on the border.
So do you find yourself rooting for like the Portland Trailblazers?
Oh yeah, of course. Yeah, they're the closest. Portland
Okay.
Trailblazers and Seattle Seahawks, definitely.
Good. Okay, final question. This is fun because I looked this up and I didn't know if you would know off the top of your head. So that's going to make it interesting. Can you name one famous person that has come from Vancouver, Washington?
Wow.
I know. There are some ones I
When you
recognize out
say
here, but I
when you
didn't
say
recognize
come
everyone.
from, I mean, there's a very famous person that lived here a long time ago, and there's even a house named after this person, and that's Ulysses S. Grant. He lived in Vancouver.
That is number one on the list. You nailed it. Number
Oh,
one is
okay.
Ulysses S. Grant, the 18th president of the United States. I mean,
Yeah,
there are a lot. There are like, I have a list of 30, but that was the number one. I was like,
yeah,
that's really fascinating. You got that one.
yeah.
Grant, thank you so much for joining the Legal Beagle podcast. I'm going to put all your contact information up on the screen and a link to your website. If people want to reach out to you, they can. I'll tell you because Grant and I got to speak offline. He's really engaging. You can see that in the podcast. Also willing to have a conversation with you just about anything. So if you have questions, even if you don't practice specifically in Washington, but just want some advice on how to handle things, Grant's been doing this a bit and can certainly add some insight. Thank you for being a guest. Appreciate the time, Grant.
Thank you so much.